Hello and welcome to Lawyered. We welcome you to the webinar on contracts for startups in Canada. The main objectives of the webinar is to help the young entrepreneurs and startups to understand the importance of contracts, and we unite the speakers to share their professional opinion on the same. Today we have Ms. Shali, who is a barrister and solicitor in Ontario, practicing corporate and business law. She's majored in international business law from Toronto and studied law in London. With that, we have Advocate Jindal. Mr. Jindal is specialized in corporate laws, intellectual property matters, and data privacy protection and maritime law. He's a multifaceted and consensuous. He's director of Jindal Solicitors and Advocates. Welcome, ma'am. Welcome, sir.
Thank you. Happy to be here.
Right. Here we have the topic, which is startup contracts. Can you please put light on what the topic is about?
Yes, of course. So, we all know that startups need to consider, having the right contracts, even in their primitive stages. We're going to be discussing some of the major ones that we think, are crucial for the success of your business. For me, especially, I'm going through employment agreements and I'm going through privacy policies. And Mr. Jindal here will take you through his run of the contracts as well. But generally speaking, we have a general consensus that contracts will protect you and your clients and that they're crucial for the success of your business because they prevent misunderstandings at the end of the day. Everybody knows what they need to do, and it's clearly stated and agreed upon. A few times, I've come across clients who don't particularly know the importance of having, let's say, a co-founders agreement. And I think Mr. Jindal will go through that a little bit more with you. But, knowing specific things like how equity is going to be split amongst founders, how whether, founders are going to be there for an adequate amount of time through vesting clauses. Those are specific examples where startups have felt that they weren't prepared enough. So that's why we're here. That's why we're sort of walking you through, important contracts that you might want to include for your startup. I think I'm just waiting for the presentation to pop up. Awesome. So contracts for startups. So like I said, I'm going to be starting with employment agreements and I'm going to move on to, so I've been through this slide already, so don't worry about that. But, and then I'm going to go on to privacy policies, one of my favorites. But, an employment agreement, please note that, these are informational lessons. So they pertain to Canadian and Ontario legislation because this is where I'm based, this is where I'm practicing. So these are applicable to mostly people who are going to be setting up base in Ontario. So if your startup is looking to, foster their business in Ontario, this will be directly applicable to you. So yeah, I really do recommend startups having employment contracts. One of the reasons being they have, sort of a degree of control afterwards over employees' abilities, whether it's to leave, whether it's to stay for a certain amount of time. At the very least, it guarantees a notice from your employees. So the ESA mentioned here on the second point, the Employment Standards Act is actually the legislation that sets out the minimum employment rules in Ontario. It's important to note that you cannot contract out of the ESA. Now, what I mean by that, I'll go into detail later, but I want to note that the ESA is the minimum. So you cannot offer less than what the ESA states to your employees. If you do, then the employees generally have a right to claim damages against you, and a lot of employers have faced that. So it's important for startups to really recognize this regulatory statute and to study it. I'll go through a couple of, points in this presentation to just reiterate the fact that you cannot offer below these rights, and that should be, something that startups are aware of from the get-go. So if I go through the types, because I've seen these as, the main types of contracts when it comes to employment agreements with startups, it's important to know the difference between them. And the only reason I say that is because it can really affect the way that litigation plays out for employment litigation. But also, if you're terminating somebody without cause, it really affects the way that an employee has an entitlement towards, let's say, damages or remedies, etc. So, of course, it's important to kind of sit with a lawyer and speak to them about the types of agreements offered and whether, one works ultimately better than the other for your startup. So it will, like, when I go through these, maybe you'll realize the types of claims that can come up. It's just an informational session, so I'm not going to go into the legal issues, but it's good to know, what kind of employment contract works for you. Okay, so the first one, indefinite term agreements. They're mostly permanent contracts. They're very common. They're probably the ones that you see the most because essentially you have parties working together until you have somebody that exits. So it can be through resignation, valid termination, retirement. There's really no date of termination stipulated in the contract. So when you're terminating, or if you're terminating without cause, you will need a notice of termination with these contracts. And then if you're doing it with cause, there's no notice or no termination pay really required. So with fixed agreements, it's a little different because you're naturally terminating the agreement. It's been agreed upon. For example, there's usually people that do seasonal work for a company. Let's say camp counselors, they probably have fixed term agreements with the corporations that they're working with or the companies that they're working with. Or you've seen those mat leave contracts. These are also applicable for fixed term agreements. If, I've mentioned this because if you do a premature termination as an employee, this is where the trickiness arises because the employees are generally entitled to damages. And that normally, because we have strict rules here, very employee-oriented rules here, that has to do with the equivalence of the remainder of the contract. So what they would be paid had they finished the rest of their contract. And then our last one that we're going to go on to is project-based agreements. You're dealing with freelance work. And this is a lot of companies I've seen, a lot of tech startups use this just because they don't need permanent employees. They just need somebody to do projects for them. So it begins and ends as needed, and it's convenient for them. This is usually labeled as consulting or licensing agreements. So I gave you an example there, which is quite common. There's IT work that needs to be done. You create sort of a project-based agreement for that person who's executing the work, and you're over and done with. No worries after that. And I also included this note here that project-based agreements and freelance workers do not necessarily mean that you're hiring an independent contractor. There is a distinction between the two of them. So when you have people that are working for you on project-based agreements, you're allowing them to use your equipment, you're allowing them to have them in work, in your work setting, in your office, and they're doing it for a specific number of weeks. They have a deadline, et cetera, et cetera. With independent contractors, these individuals are not necessarily protected by the ESA. So it's important to know which one you're hiring. For independent contractors, they're generally not expected to perform specific work, or they're not expected to show up at the office or use your equipment, or told how to do their job generally. Okay, so that's kind of the distinction. There's obviously more to it, and you would speak to a lawyer to figure that out. Okay. Things to remember. So these are just little pointers that I think are important to know. An employment agreement can be either verbal or written for indefinite or fixed term agreements. Now, it is also important to note that A lot of the time there are terms or clauses that need to be in written format for them to be executed or argued in court and or tribunals, in front of tribunals. So this is something that only a lawyer can advise. It's a better call for startups to kind of sit with their lawyers or hire a lawyer for consulting to provide them with that information. But what I will tell you is that employees must be given their minimum statutory entitlements. So that's according to the ESA. If you ever want to sit down and study the ESA, they'll go over these points with you. So the hours of work, the overtime pay, the minimum wage, vacation time, and more. So all of this, including more, this is a non-exhaustive list. Really, the minimum standards need to apply in your contracts. And I've added a point here about hiring foreign workers because we do have an international audience. So if you're on the receiving end of an agreement from an employer, you really want to make sure if you're applying for a work permit, let's say, that your contract with the employee resembles the information that you're putting in your work permit. I thought I'd just say that because it's important for people to realize that, in order to get the successful work permit, it's ideal to have a job description, terms and conditions of your employment agreement that sort of replicate what you'll be doing in the country that you're moving to. Okay. All right. Next is a few other things to remember. So if you eventually want to change your employment agreement, be careful. And the only reason I say this is because startups don't, I have a lot of founders, co-founders, entrepreneurs that don't think too much into the future about employees and their contracts. But it is important to note that, you have to be really sure about your employees. You have to be really sure about the clauses that you put in your employment agreement, because if you ever choose to change it and it's considered to be a unilateral or a fundamental change, it can constitute constructive dismissal. And sometimes you have other legal issues that come up as well. So employees might be entitled to remedies, et cetera, because you're taking away their rightful rights. So it's important to note, for Canada at least, that courts here don't really take lightly to employees that violate the ESA. They'll strike off the offending clause and you'll likely be liable for damages. Okay, so last thing I really want to go through is just, for employment at least, is the clauses. I mean, I think it's important to discuss some of them. A lot of them are very self-explanatory. So if you're dealing with an employment agreement, these are generally things you're going to see. It's good if you can reference back to this as an employee or an employer to see if you're doing the right, see if you're including the right clauses in your agreements. So I will be talking about employment offer and probationary periods and layoffs. So employment offer is obviously just the offer that you're providing the individual. It has, beyond these points, it has details of the job. And it really prevents misunderstandings from forming. So you execute a contract which gives the individual the scope of the employment or what they're expected to provide to you. The other ones, so the other ones that I've mentioned on the right-hand side, for example, are sometimes just guaranteed by the ESA. So they're already, their statutory minimum requirements are guaranteed, and the contract itself can improve what the employee is getting, such as, let's just say the employer gives you more money instead of the minimum wage. That's something that's beyond the ESA. But like I've mentioned, the minimum requirements should be there so you don't undermine the rights of your employees. And then the probationary periods and layoffs is also not a freestanding right. So I'm particularly talking about the probationary periods. A lot of employees like to include 90 days, for example, of a probationary period, or 3 months, so that they can evaluate the employees and see that they meet a certain criteria of work. This is not a freestanding right. So if you're including that in an employment contract, for example, you must agree to it with the employee. So it must be a clause that you include in your employment contract. You can't just one day say that, yes, well, there was a probationary period, so I'm letting you go. So the rest of them, pretty self-explanatory. These are things that you should be including generally in your contracts. You have the responsibilities and hours, termination clauses, confidentiality, entire agreement clauses, which was quite standardized, and ADR clauses. So ADR can really help prevent costly litigation in the future, and you're just dealing with alternative dispute resolution. So mediation, arbitration, giving everybody an option. Okay, so that is the end of employment agreements. I'm moving on to policy agreements, which is, sorry, but privacy policy agreements, which is one of my favorites because a lot of startups these days are concerned with that, and a lot of clientele of theirs are concerned with that. So we have here the Personal Information Protection and Electronics Document Act. PIPEDA is what we call it. And it applies to most organizations and businesses in Ontario, but it also applies to private organizations across Canada. This is basically referring to organizations that are conducting commercial activity, okay? It's enforced by the Office of the Privacy Commissioner of Canada, and it does not apply to organizations that are not commercial or organizations that are not profit, okay? You need to make sort of information available to your audience. And what I usually tell startups in this space is that this is a really personal agreement that sort of connects you to your consumers, because everybody has a unique twist on their policy agreements. It's really just making it about your own business. For example, you kind of make clear what personal information is collected and for what purpose. So you can be collecting identification documents, numbers, date of birth, social media logins, automatic information, which I'm going to get into. You can even be collecting video surveillance images or cookies, and you really need to state the purpose why. So it could be for identification, verification, security. It could be for just marketing. Oftentimes as well, I've noted here, you'll need both a privacy policy and a terms of condition. A terms of condition usually refers to the privacy policy and vice versa. So when a reader is looking through these policy agreements on your website, on your application, they're agreeing to this before they're able to use the actual service. Okay, so a couple of things to note is that, so like I said before, actually, before we move on to that, make it about your business. For example, make clear what personal information and for what. The reason I've stated avoid boilerplate clauses and standardized wording is because that is quite literally what I want you to do. I want you to have a conversation with your clientele instead of having a very legalese-filled document for your clientele to read before they use your website or before they use your application. People look at this policy in order to kind of know what information is automatically collected. Also, information that may not be automatically collected, but they just don't realize that they're giving it to you and it's saved on a database. But also how it's disclosed, how it's used, how it's disposed of, which is why you really need to be particular about what your business is using it for and what ways or methodologies your business uses to collect that information. Okay. Okay, so it's great. A lot of people have actually come up to me saying that I really saw this nice privacy policy. Can I just copy paste it? Well, here's the thing. I really love when people do their due diligence and they go and they read all these privacy policies. For example, if you go see Pepsi Canada's or PwC Canada and you read their privacy policies and it pertains to you and things that your business is doing, it's good to use them as a reference. What I would say is using them as a reference for style, for formatting, maybe even the approach that they take, conversationally with their clientele is great. But having that unique spin and having clauses that are unique to your organization, I think are more imperative. So yeah, that's what I would say on that slide. I think on the next one, I actually give you an example, right? So this is a standard clause that I would have in privacy policies in Canada. I kind of want you to gain an understanding of things that we include. So I really think that privacy policies are best learned if you're actually just going through the clauses, if you're understanding what needs to be included in order for you to be transparent as a corporation. So this is a standardized intro clause. You're recognizing that you're a national organization. You're saying that it meets the standards of COPEDA as well as provincial policy, legislation, and regulations, et cetera, et cetera. BC and Alberta actually have variations of COPEDA, which is why they're individually mentioned there. Okay, so that's something that you can refer to if it ever, occurs to you that you need to write an introduction. And then this is a great reference. I think if you ever, so COPEDA, I'll get into this a little bit more, actually offers 10 fair information principles. And a lot of the times you can use these principles to guide you in drafting a privacy policy or making sure that your lawyer has drafted an adequate one. These are the things to include. And I'm going to go through a few of these, not all of them, a few of them that are very imperative to kind of look internally and see how you fit into answering that question. So, COPEDA itself offers practical steps that you can take to comply. And these are the FAIR principles. So I actually have a list of the FAIR principles. I know I haven't mentioned them in this slide, but if you are taking notes, I'll give you the list right now. I've actually condensed them into 7. So you have, these are really the ground rules for the collection, use, and disclosure of personal information, as well as providing transparency for your clients. So you're talking about, these are the principles. You're talking about accountability, identifying purpose, consent, limiting the collection, use, disclosure, and retention of personal information, accuracy, safeguards, openness, individual access, and challenging compliance. So these are things, even if you look up COPEDA and you find the 10 principles, they'll be there. It's very concrete. And you use that as a framework to create your privacy policy. And these are the clauses that would naturally just come up because they're questions that answer those principles. So we'll go through a couple of them. I mean, I like going through these because they're very relevant to tech companies, especially nowadays, that are using application devices, and they're very relevant to all businesses that are using websites. Okay, so what is personal information? Oh, I'm just going to move this slide. Great, thank you. Okay, so personal information, this is a non-exhaustive list. So it includes but isn't limited to your mailing address, telephone number, obviously your name's on there as well, email, IP address, age, gender, marital status, health information, financial status, credit card information, credit history. It's this is great to even copy paste if you want to put it into your clause, because this is the definition of personal information, and it's quite standardized. It doesn't include the business title, business address, or telephone number of your capacity as an employee at that place. So that would be pretty much your answering that question and ticking off the box to actually defining what personal information is for your clientele. How do we collect the personal information? This is usually quite a long piece. So you have 2 sections to this, actually. You have automated collection and you have manual collection. And you obviously don't have to word it that way. It's just personal. But there's always information that's provided by your clientele voluntarily, such as names, email addresses, phone numbers, other similar information. But there's also, and social media login, like the second point says, because the person is actually registering it with their social media accounts to use your account. But they also have sort of automatic information, and I'll get into that in the next few slides. So it's important to note when you're doing this clause that you're always collecting personal information by a fair and lawful means. So it's usually when you're telling them that they're engaged in providing service, or us providing services, or when they use our application, or when they use your website, or speak to one of our representatives or your representatives. That's a good way of letting them know that this is how we do it. There's also, depending on the context of the interactions, the choices, the features that you use on the webs and the applications, that information changes that we end up collecting. Okay. So again, the prior slide kind of went into personal information that was provided by the individual. This is more of the automated information that companies end up collecting just through people using the website or the application. And it's important to note these because people need to know what they can sort of opt out of versus what they have to use in order to use your services. So you have login usage data. It's usually service related, diagnostic usage, performance information on specific servers. It's usually log files that are created when people use the service automatically. So you have a list here that I've mentioned. So you have the IP address, the device information, the browser type, et cetera, et cetera. The device information, such as the system activity error reports. So a lot of things that people are unaware of that are being collected. But if you have that in a clause and you're being transparent about the fact that you have this, it's good because they're aware, they're reasonably aware. You've brought it to their attention. They've agreed because they've continued using your service or your website or your application. Okay. I think the next one we go to is cookies. Yes, cookies. So cookies, we're all aware about cookies. They're small text files, technically placed in your hard drive. So generally people use them for a more customized experience, more efficient registrations, for example, because a cookie, for example, can be used to store information when people log in, so they don't have to keep putting it on, putting their name and their passwords in and things like that. So that's automation. That's a more efficient system of getting people to register or utilize the website. Give your clientele a choice to opt out of it. I think it's very important that you are transparent in that sense, because we have a standard here of being quite transparent with clientele about what kind of information we collect and what we do to it. So if you give a clause that states, if you're concerned about it, you're able to decline it, and you can still fully navigate our services, then that's great. You've done your work there. That's what I would say about cookies. Then you have device data and location data, quite a lot. So device data is obviously about your computer, your phone, your tablet, other device. It may include information like your IP address, proxy server, device application identification numbers, things like that. So it's important to kind of mention that you're using that as well. Location data, quite self-explanatory, but here I always recommend having a line about disabling or having the option to opt out. And when you do that, be sure to mention the restrictions that you're imposing as well, because there are a lot of scenarios where if location is not provided, you can't use specific aspects of a service. So that needs to be stated that, if you choose to opt out, you may not be able to use the certain services provided by us for, including X, Y, and Z, or you just leave it at that. Okay. Right? Okay, so how do we use your personal information? This is quite overwhelming, quite long, but it's just a list of things that you might want to include. It's not an exhaustive list by any means. These are just examples that have been used. Personal information is normally stored on servers. That's standard. And for companies, you would know better. So when there are things in the cloud, or where there are locations around the world, or that there are going to be multiple servers internationally, these things need to be stated in your clause. Excuse me. So this is a list that you can probably include about how we use your personal information. You use it because you want to provide, operate, and maintain your website, or you want to improve, personalize, and expand your website, etc. There's an endless list. I thought it would be a good reference for you, as opposed to me going through all these points. These are things that you can easily include in a clause like that. Of course, mentioning sort of what I mentioned before, that if you're holding it on servers, if you're having it in the cloud, um, if it's multiple servers internationally, do state that. And do state the fact that if it is international, it might be that international laws or the laws of that country would be applicable if that's what you're dealing with. Okay. Okay, so yeah, to whom do we provide your personal information? Yep. So this is quite a long one. I typically work on it with startups just to get a feel of what they're doing with the information and what type of business they run, i.e., what type of intermediaries you may come by. So, with consent, for example, you might want to say that we're going to process your data in certain scenarios when you've given us the specific consent to do so. Legitimate interest is sort of, when it's reasonably necessary to use your information, we will for legitimate interests, and you sometimes define the business interests. Sometimes you don't, you leave it open. Performance of a contract, obviously, if you want to fulfill the terms to a contract that you have, and you'll need to disclose information that might be necessary, that's something you may want to include. Legal obligations come under the bracket of you have to comply with applicable law, so you need to disclose the information. Vital interests usually have to do with when you're investigating anything, so if there's suspected fraud, potential threats of policies, or to the safety of any person or any illegal activity in general, sorry, then this clause would save you there. Okay, a lot of the common ones, though, have to do with business transfers. So you might want to include the fact that you would share or transfer information that's connected with any merger, any sale of company assets. That is what I mean by business transfers. If you're dealing with vendors, consultants, and third-party providers, that's usually stipulated in the type of service that you provide. So if your clients are going to use a third-party service through your website, then you know that information needs to be provided to that third party. Okay, how do we secure your personal information? It's also very informational, but it's also very personal. So how you secure it, you can be implementing physical, organizational, contractual, technological security measures. You could define the way that you're doing it. A lot of people use the SSL, which is a secure socket layer technology. And I've even, I think, added a note there. So SSL is a security technology for establishing an encrypted link between the server and client. It protects pretty much secure, very sensitive information like credit card information. And that's good to tell your clientele. Okay. And then you have a couple of others. I know that I didn't want to go through all of them because it was just very extensive, but these were the main ones, and these here are also, ones that you want to consider. So that's the end of my presentation. I hope that helped. If you guys have any questions, please let me know. Be happy to answer them.
Well, I think it was an amazing presentation. You really did cover a lot of aspects, and I'm quite elated to learn so much from you.
Thank you, Mr. Jindal. I'm excited to learn from you as well. Of
Hopefully.
course.
So, how do we present? Yeah, so my first topic is relating to the co-founder agreement. And So I will delve into various aspects of the co-founder agreement and with the positive time, because this can be a very extensive agreement. I will try to keep it short and sweet. So I will discuss what is exactly the co-founder agreement. I will explain it to our audience. I will talk a little about the importance of a co-founder agreement and give you some of the boilerplate clauses, because, well, obviously, like any agreement, this can be quite an extensive agreement. You can add as many number of clauses as you want. But I will just give you the standard boilerplate clauses. And for other clauses, well, I will suggest you go to an attorney who can help you out. And then I will give a small explanation of all the clauses. So, what exactly is the co founder agreement? A co founder agreement is an official contract executed between all the co founders of the company. Well, it is similar to a founders agreement, and well, in Canada, you do need to have a founders agreement, especially if you're trying to raise a funding through a VC or maybe an incubator or an angel investor. You will need to have certain documentations in place, which you will be required. So this is one of those documents, and though it mostly is relating to the equity share of each of the partners, but that we'll delve into in another thing. Here, I will explain what exactly the importance of co-founders agreement from a different perspective. So it is an official contract executed between the co-founders of the company. From the perspective which I'm going to talk about is that the importance of the co-founders agreement is to prevent disputes among the parties later on. I believe that it is really, really important that you have the rights, roles, responsibilities, and everything sorted between each other before you enter into business. Because what happens is that a lot of times I've seen so many startups, so many such amazing startups with such amazing, beautiful ideas, which end up failing because of minor disputes among the among the founders, and they end up often like just breaking apart. And I believe that the co-founders agreement can really, really help prevent that, because you basically give an outline of the business, ownership, rights, responsibilities, equity ownership, the governing laws, and other provisions which are required, and as what is agreed between the founders of the company. So, when we go into the importance of the co-founders agreement, well, as it has been mentioned in this amazing presentation, that a poorly constructed founders agreement can result in killing of a startup. Well, this was mentioned because I read it somewhere, and I read it as a law student, actually, when I had attended a seminar. And when I think about it, it is absolutely true, because when I came into the profession, I used to see so many startups, like I mentioned before, who just vanish because of disputes among the co-founders. And this agreement provides an insurance in case of disagreement between the founders, because because when you start a startup, you're not just a person who is doing one particular job. You have to look after the finance, you have to look after sales, you have to look after management, you have to look after so many other perspectives. You also have to look at the legal issues at times. And one of the main reasons we prefer working as a team, so that the responsibilities are divided. But as we have heard, that too many cooks come and spoil the broth. Well, why does the broth get spoiled? It is primarily because they have not distributed the responsibilities amongst each other. And that is what causes disagreement. And but when you have a co-founders agreement in place, when you have a very good agreement in place where all your responsibilities have been well distributed, there is a sort of an insurance that, okay, if maybe I am I have entered a startup with three other people, and being a lawyer, I'm taking care of the legal responsibilities. My friend is taking care of the finances. The third co-founder is taking care of the management. So if tomorrow I don't take care of my responsibilities, they can tell me, yeah, as per the agreement, you were supposed to take care of the legal aspects, but you didn't. And similarly, I can ask my co-founder that, okay, you were supposed to take care of the managerial responsibilities, but you didn't. And so this forms kind of gives an assurance in case of a disagreement. And well, it clearly states the roles and responsibilities needed to execute. And it will also give you basic details, though there may be other agreements, for example, a partnership agreement or an MOU, a member of understanding. But this does kind of give you a basic detail which you may add regarding the relationship between which all the founders of or the co-founders will have amongst each other. And well, obviously, when you have everything laid down, there will be a very less chance of a deadlock. So here are some of the boilerplate clauses, and well, I will like to go into them one by one. So, as well, we keep repeating this thing that we'll be going over the roles and responsibilities, because the primary reason for this is that because it is very, very important that the roles and responsibilities are well sorted and well distributed amongst each other. And they are very clearly defined, because very clearly defined roles and responsibilities will actually prevent any dispute from occurring. And it should be very, very well drafted, and we should go into, and please, I really request all my clients that you should go to an attorney who can actually go into the depth and detail of each and every aspect of the agreement. Because what often happens is that people may when people don't go into the depth, and it is really important for your attorney to hire an attorney who can actually understand the depth of the business and your business, who understands the business. Because well, as I though it might be sounding a little this thing, but often attorneys don't understand the business intricacies as well as a founder does, because the founder is the businessman and he knows the internals of the business. So it is really important for them to sit down together and understand the intricacies of the business, so in order to clearly define whatever roles are to be distributed and how they are to be distributed, and so that there is no dispute later in the future. The second important clause, though, can be formed into a separate agreement as well, because it's more of an optional clause agreement, depending on whether you want to have it as a separate agreement or whether you just wanted to add it into this co-founders agreement. This clause is basically to protect the interest of the startup, because often a co-founder may it's not often though, but sometimes the co-founder may find a better venture or a better option and might leave the startup. And in such a case, it is very important for the startup to protect the clients and the resources they have spent on creating certain skill and clientele from being maybe taken advantage of by another organization. And in such a case, having a non-compete and non-solicit obligations will really, really help the startup in preventing such a thing from happening. And uh, it will also it should also state the number of years, because it is an option though, but often it may happen that when the startup co-founder may leave, they may try to poach the clients which they've brought. And so in such a case, it is also important to have this clause. And you can also state the number of years for which the co-founder cannot join another business, or which will be a direct competitor of the startup, or maybe start their own business which will be a direct competitor of the startup. Then the next clause is regarding the equity ownership. This clause mentions the consideration invested by a founder in the form of monetary investment, experience, network, and IPRs. Well, each co-founder definitely brings something new to the table. I may be a sleeping partner or sleeping co-founder in the organization, and though I may not be actively involved in the affairs, but I may have invested my capital, or maybe I have a patent based on which we have created a certain product and we are selling it into the market. And in such a case, I would prefer having equity, even though I may not be actively participating. Or there might be another co-founder who would be actively participating in the business, but he may not be bringing anything, maybe capital or any other thing. So it is very important to define the equity ownership, or how much percentage of ownership in the startup each co-founder will have. So depending on what they're bringing or whatever considerations are there, and and it should also be helpful in defining whether there will be any division of profits among them. Sometimes a co-founder may even be drawing a salary on the work being done, or for in addition to the profits. So that should also be defined. That can also be defined. Then another clause which I feel is very important to have in a co-founders agreement is relating to vesting. So often startup entrepreneurs, they or the promoters of an organization, they may enter into an organization, work for a certain amount of time, take it to a certain level, and then want to move on to other ventures. In such a case, it is very important to have this clause, or it might also be certain circumstances where the co-founders may think that, okay, now this person should be removed, and this person is not being able to keep up with the obligations which were imposed on him as a co-founder. And in such a case, it is important to have this clause, that how will the remaining share be distributed amongst the co-founders, in what proportion it will be distributed, and and how the responsibilities will be taken. And there are two forms of vesting. One is time based vesting, one is milestone based vesting, where if a co-founder, maybe after 2 years, he will move on to another venture, so his share will be taken up by the other co-founders in a particular proportion, or after the company has reached a certain level. For example, maybe there is a milestone that, okay, once our valuation crosses 1 million CAD, we will one of the co-founders will leave to go for another venture. And so it might be time based vesting or milestone based vesting. Then another clause which is very important as per my this thing is how we will be assigned to the organization. Though there might be a separate agreement to this as well, but this might be added in the co-founders agreement, where you mentioned that so like I mentioned before, maybe we are opening a restaurant. I developed this amazing recipe, and I decided to, with one of my friends, that okay, let's open a restaurant chain, or two, three of my friends, and we all became co-founders of a startup. And well, so now the question will be that who will own the patent of the recipe which I created? Mm, will it be the entire, all the members who are having equal ownership? Have I given a license to the startup to use my patent for selling that product? Or have I transferred the ownership to them? So this also needs to be very well defined, because who owns the patent? Who will own the IP? Similarly, it can be for a trademark, or maybe even a copyright. And it is very important to have this defined as well. Then another aspect which needs to be clearly defined is confidentiality, because like I mentioned, they might not, it's not just about maybe a patent or any intellectual property which needs to be confidential. It can be anything. It could be a marketing strategy, It could relate to my to the firm's financials. It could relate to anything in the firm, and it and leaking of certain information may actually be catastrophic for the startup. For example, if you take up maybe uh, Pepsi, the formula by which Pepsi is developed, if it gets leaked into the market, there have been so many companies who've tried to recreate the formula, but they have not been able to. And if it gets leaked, it will be disastrous for the company because it's a formula which they created and have protected for so many years. So that is why it is really, really important to have confidentiality uh, clauses in place so that whatever special thing they have by which they are able to sell or whatever confidential information they have, that's kept safely and securely. I will delve more into the confidentiality clause or a separate confidentiality agreement later on. And then the another clauses regarding employment and designation and uh, so sometimes a co-founder may be even employed by the startup. So I may be uh, by virtue of being a co-founder, I may be appointed as a CEO, or I may be appointed as a manager, or I maybe even be appointed as maybe VP sales or president sales. And in such a case, it is really, really important that my employment status and designation allotted to me, along with the benefits I have. Maybe I get a company car, or maybe I'm allowed to draw a salary. So it must be very clearly defined, and along with the responsibilities I will be having, though it might be also be done through a separate employment agreement. But this may a point relating to this can also be should also I believe should also be given in the co-founders agreement. And it might also happen that though I may be taking good care of my other responsibilities as a founder, but as a sales VP, I'm not a very good sales VP. So in such a case, what will happen? That also should be defined in the co-founders agreement. And uh, representations and warranties. And so this is also a very important clause, I believe, into the co-founders agreement, because often, like I have mentioned here, that investors, we may try to be raising funding, and I may go and make a certain pitch to the investor that okay, we will reach this valuation. My other co-founders do not know about it. So in that case, whose responsibility will it be if you're not able to reach that certain level? So that also should be well defined, that in what cases and up to what extent can I make any representation before any third party. It may be an investor, it may be a client, it may be a general advertisement as well. And I maybe even be speaking on a public forum. So up to what extent I can represent the firm, and up to what extent can I make promises? And maybe we there could be a cap on the contract. So for example, I cannot enter into any contract above a certain amount, or maybe for entering into certain services with a client where I'm selling a certain product to the client. I mean, there might be a cap on that. I cannot give a concession of maybe like more than 5%. I cannot give a discount of more than 5% to any client. So this should also be well defined. And and the most important, so these are the most important points, because what can because we never know when a dispute may occur. So it is really important to have things in place where that how in case of a dispute we will be resolving it. Maybe you may have a certain clause that for the first 15 days after a dispute occur, you will try to resolve it, or you will sit amongst yourselves and try to resolve it, talk it out amongst each other. If that doesn't happen, then maybe you'll go into mediation, or you may even try other forms of alternative dispute resolution, such as arbitration. Or well, if nothing else works, then you know you may go into court. So you can have everything defined. And the governing laws, you will have the governing laws set into place, that how which laws will be governing your startup. And though for the this in agreements, you have to know that you will first that you can only set jurisdiction for the you can only limit the jurisdiction under contract if I have a statutory jurisdiction. So you have to take care of that as well. That you have a statutory jurisdiction, and then you limit the jurisdiction under contract. So that is something you really, really have to take care of. Yeah. So
Thank you so much. Thank you so much for such informative insights on startup contracts. Thank you for joining us today. We are sure that the session helps the viewers in understanding about the agreements that are required for startups in Canada. Thank you, sir. Thank you so much, ma'am.
I had another topic.
All right.
Hello.
I think Miss Shali, we've lost Miss Shali here.
May I start presenting?
Yes, sir. Mm.
There we go.
So, the next topic which I have is relating to non-disclosure, non-solicitation, and non-compete agreements. Uh, what is most important to remember about these agreements that is that they can also be added as a general clause to an agreement, or they can be in the form of a separate agreement. I will keep this, seeing the paucity of time, I'll try to keep this short and simple, and though I will try to cover every basic aspects of each of these clauses in detail. And each clause or agreement may be specific to a situation, or so I would always recommend that you consult with an attorney before you draft such an agreement or such a clause. And though you may use a boilerplate one, but I will always, I always recommend custom-made clauses and agreement. And well, the primary purpose of all of these clauses is to protect the interests of the startup. So the parties to these agreements, these are quite, though they might be certain parties which may not be relevant to certain of these, but they are generally relevant to all of these. So they are co-founders. Well, obviously, these are the confidentiality, non-solicit clauses, and are quite important to have among the co-founders. So in order to protect their interests among employees and investors, because you do sometimes reveal various information about the startup to the investors, who and sometimes investors may actually become quite involved in the various aspects of the business. So it is quite important to have non-compete, non-solicit, and confidentiality clause with the investors as well, because you will be, in order to raise funding, you'll be sharing various aspects of your startup to a lot of these investors. So it is very important to have these clauses or these agreements with them. Then consultants, you when you are going to start a startup, you will be indulging with various consultants. You may be indulging with someone who will help you raise funding. You will be indulging with someone who is engaged in trademarks. You will be indulging with maybe an accountant who will help you with your accounts, and various consultants. And it is quite important to have these agreements in place with your consultants as well, especially your confidentiality agreements and even the non uh, other agreements as well, because maybe you have a consultant who knows various intricacies of your business. And along with the confidentiality clause, you may also add a small non-solicit clause that for these many years, once you know about the intricacies of my business and the profitability of my business, you cannot start a business, similar business, because otherwise you may actually, you never know when things might go otherwise. This actually happened with one of my clients, so that's why I recommend this. And well, with contractors, you may be hiring freelancers or part-time employees, and uh, and other contract or people on contract basis. So it is important to have these agreements with them as well. And clients as well. Even you sometimes need to have a non-compete and non-solicit agreement with clients, and even the confidentiality one. Uh, Well, I will give you a very classic example of this, which happened with one of my clients. It's quite a funny story that one of my clients, so they had started a course in which they were teaching various aspects of a certain field. And one of the students, they actually came, they learned a course, started a similar online academy, and they grew way more than the original course instructor. And they actually kind of sold the same things which were being sold. Like the material was also quite similar. In fact, they even filed a suit against them for infringing on their IP. And it is so in such a case, it may be important to have such a clause from the beginning, that maybe you cannot start an edtech course based on the same material, though it will have to be seen whether it can be how much people will comply, because people always do find loopholes, but there's no harm in adding such a clause. And I will straight away dive into the agreements. So the first agreement is the non-disclosure agreement. It creates an obligation to protect confidential information of the startup, and it is created on basically created to on various stakeholders, and it is supposed to uh, various who may have maybe a separate clause, or maybe entering into a separate agreement between the parties and the various stakeholders. And the stakeholders, as I've discussed before in the previous slides, that they might be your employees, investors, co-founders. So it basically protects the confidential information of the startup. And this confidential information may range from a lot of things, from trade secrets, proprietary information, marketing strategies, client information, product information, procedures and specifications, and a lot of other information, disclosure of which would harm the business and their competitiveness in the market. Because every business has certain thing, every successful business has certain thing which gives them an edge over the market. And when you lose it, well, you'll be out of the market. So it's very important to protect that. The next point which I would like to discuss is that this information can be either general or specific. And you may create a confidentiality agreement where you only protect a certain specific information, maybe relating to buying in a trading firm. You may restrict information relating to the price at which you buy and sell the product, or in order to protect the margins you're making. But other information you can share, okay, yeah, you're trading in maybe garments. And and in some aspects, you may want to protect the entire information. For example, you may be a consulting firm, and you may have a lot of confidential information of your client, and you would want to protect each and everything, each and every aspect of it. And these agreements can be time bound as well, that okay, maybe for like 3 or 4 years you cannot disclose it, but later on you can, though it is more of an optional this thing, because in confidential information, people usually want to keep it forever, under wraps. And so, though this is a very optional clause, but maybe yeah, you can add it. And then the most important aspect, I believe, of this agreement is a stipulation of damages. Because, okay, yeah, you had a very strong clause, you had everything, but still, someone, maybe one of the parties, they just decided, okay, we don't care about this agreement, we'll just go and violate it. And yeah, they violated it. So, what will be the damages? Because in such a case, it is usually quite difficult to ascertain the loss which occur to the startup. So, and most of these damages are unliquidated damages, and it is very important to set up, also keep a way of how these damages will be calculated, whether you will be going through mediation or whatever the process will be. So, it is also very important to have the method by which they will be calculated. And you may also mention that, okay, this is the certain, you may also mention a floor or a cap, that, okay, if such a thing occurs, there these many damages, okay, maybe like 10,000 CAD, this will be the minimum amount of damages which will be paid in case such a breach occurs. Or and also a cap, okay, yeah, maybe not more than 1 million CAD. So you can keep everything accordingly. And now I'll move on to the next agreement, which is the non-solicitation agreement. So this agreement, or it can also be added as a clause, puts an obligation on the parties, or either one of the parties, to not solicit clients of the startup. This agreement is primarily agreed on between startup founders, and is a standard to be signed while employing a person by the startup. This clause is very, very important uh, in order to prevent the poaching of clients by parties based on relationships developed by the startup with various clients. Because various stakeholders, when they are involved into the business, they get into touch with a number of clients. And no startup who has put in so much effort, so much resources, so much time in getting a client, because getting a client is a very, very difficult process. It's a very painstaking process, especially for a startup who is yet developing and establishing themselves. And if somebody just poaches their hard earned client, so it's a very heartbreaking thing. So it is very important to have a non solicitation agreement in place in order to prevent such a thing. And the importance of this clause, it's basically stems from a fiduciary duty owed by various persons who get associated with the startup. They have a fiduciary duty to not come and poach the clients of the startup. And this may be both be geography bound or a time bound. And by geography bound, it basically means that you cannot poach. Maybe if my startup is operating only in Ontario, or maybe operating only in Canada, or maybe it's operating only in Vancouver. So the only clients who are in Vancouver, you cannot poach them, but you may go and approach other clients in maybe Saskatchewan or any other, or Yukon. So now I will move on to the last uh, topic, which is the non-compete agreement. This agreement, or this clause is primarily made in order to ensure that certain stakeholders or parties do not later become a threat to the startup based on skills and connections developed while working with or for the startup. When you are working with a startup, well, as I've mentioned, that you develop a lot of skills, and you know how to run the business. You get to learn how to run the business. You get to learn the intricacies of the business. It will be really heartbreaking for a startup who has put in a lot of time, resources, and everything into helping you develop those skills. and later on the person on whom this investment has been made ends up becoming a major competitor of the startup. So it is very, very important to have this clause in place, and this is primarily, mostly though, it is kept between towards, more geared towards employers and co-business owners or co-founders, and though it is also applicable on others, even your clients, like I had mentioned when I had started this topic. And this as the previous clause, this clause is also both time bound as well as geography bound. With the non-compete clause, a very important thing has to be seen, that it should not encroach upon the right of the parties to of livelihood. So section 6 part 2 of the Canadian Constitution Act provides for a right of livelihood, and as a business owner, you of a particular country, it is very important to respect the laws of the country and as well as the ethos of the laws of the country. And any such clause should not be an undue restraint on trade and should not prevent the parties from exercising their right to trade. And taking a look into this, the Canadian government started imposing some restrictions on these agreements, particularly to protect the interest of employees. But the recent Ontario government has imposed a restriction through the Working of for Workers Act, whereby they have imposed a restriction on workers from adding on employers from adding a non-compete clause restricting employees from working with competing firms. It is of really important for a startup to ensure that they are taking into consideration whatever laws are there and whatever laws are binding them. And this clause was basically added in order to protect interest of workers, because often employers would add these clauses, and employees who would have these developed skill sets, they would just not be able to work anywhere, and this was a major hindrance. So as a result, this law statute was passed, and I'm sure that slowly and slowly other provinces who have not yet have such laws, they will also start passing similar laws. And it is really important to consult an attorney before developing any contract. So uh, I would really recommend that any startup founder to take into consideration such clauses. And as I've mentioned before, that courts have considered the existing. So if you have a poorly, so you have to ensure that seeing this, that if even if your province does allow you to have a non-compete clause or a non-compete agreement, uh, it should be very, very narrowly drafted, and it should be very properly drafted, because often Canadian courts have considered the existence of a non-competition period in determining the period of reasonable notice. And a poorly drafted clause or agreement could lead to costs on the startup, even if the province in which it is situated allows a non-compete agreement or clause. And if this had not been poorly drafted, it would later on lead to losses to the startup, and they would have to pay costs. So it's really important for them to take these into consideration. I'm thank you for allowing me to give this presentation. It was a really, really great honor to share the podium with Ms. Shali, and thank you for bearing with the long presentation.
Likewise, Mr. Jindal, amazing job. I learned a lot.
Thank you.
Thank you so much for such an insightful information on startup contracts. We are sure that the session will actually help the viewers to understand about the agreements that are required for the startups in Canada. Thank you so much and have a great day.
Thank you. Take care, everyone.
Thank you. See you. Thank you.